I have closed the breakout room. Everyone, I believe, has rejoined us. And I think I have resumed the live stream on YouTube. So, are there any announcements, Ms. Freeman?
Yes, Judge, I believe the James Brown will be a consent bond. I've just forwarded that to Mr. Williams.
All right.
And other than that, I believe the other cases will be hearings.
All right, so I plan to hear the private attorney cases first in the order as they appear on the calendar. Right now, it appears that the first hearing we will have is State versus Montrell Freeman, followed by State
Judge
versus,
West?
yes, ma'am.
I'm sorry to interrupt you. We may have to wait on Freeman first for them to bring him over from the jail.
Okay,
Okay,
all right, thank you.
he's coming, but we may don't do him first.
We got him.
Oh, you got him? Crowley,
Okay.
you have him?
Yes, we got him.
Okay, never mind, Judge. You can do him first.
Thank you. Then we had State versus Reginald McCrimmon. However, the attorney representing Mr. Crimmon, Max Hirsch, is not has not yet made an appearance. So if he's not here by the time that we reach him, we'll move on to State versus Lauren McKinney, represented by Mr. Strozier. Then State versus DeLacy Young Wilson, represented by Mr. Studdard. And then we will move on to the cases being represented by the Public Defender's Office in the order as they appear on the calendar. So, is it Deputy Carter working the jail?
Deputy Crowley, sir.
Okay. All right. If you will bring out Mr. Freeman for his hearing.
Cheryl,
Yes,
we need that waiver signed.
okay, I will forward it. Let me, because I'll pull it up now.
I just forwarded it to Judge West.
Okay. Thank you.
You're welcome.
All right, Deputy Carter, James Brown can go back. I have signed the consent order for bond on him.
Yes, sir.
All right, court calls for hearing the case of State of Georgia versus Montrell X Freeman for purposes of bond hearing. Mr. Freeman is present, represented by Attorney Carrington Matthews. This hearing is being conducted by Zoom video and is being taken down by court reporter Latasha Coleman. The state is represented by Assistant District Attorney Cheryl Freeman. This is Judge William West presiding by designation of the Superior Court. It appears from what information that I have been provided at the last moment that Mr. Freeman has waived his preliminary hearing and reserved the issue of bond. He is charged with theft by receiving stolen property, possession of firearm during the commission of a felony, fleeing and attempting to elude, and a center turn lane violation. Mr. Matthews, I don't know if there's a previous bond that was authorized for Mr. Freeman at first appearance. I don't know what the status is at this point, if he has any bond at all. So
Yes.
I'll let you proceed with your case.
Yes, Your Honor. Thank you. Good morning to this honorable court. Attorney Carrington Matthews and Attorney Teresa Mahfoud are here representing Mr. Montrell Freeman. Your Honor, Mr. Montrell Freeman does have a bond on these charges. He has an aggregate bond of approximately $66,000, if my math is correct, on the amounts for each particular enumerated charge. Just to give the court a little background concerning Mr. Montrell Freeman, Your Honor, he is 17 years of age. He is a high school senior at Mount Zion High School. He does have family members that are viewing this live stream on YouTube. Your Honor, he has been a fairly good student at Mount Zion High School. He has a GPA, cumulative GPA that is 2.295. However, Your Honor, what I can say about his educational background is that he is a rising senior. He's attended all of his classes last year. He had, judging on the attendance record, it was outstanding. It was superb. He does attend school. He actually has a letter. All of these documents I have provided to the state of Georgia prior to this hearing. Your Honor, we have a letter from Mount Zion High School from one of his teachers, Miss Michaela Highland. She spoke very highly of Mr. Freeman. She indicated that when she first met Mr. Freeman, she met him because Mr. Freeman was on the football team there, and that she needed some help moving some chairs and things. He was very helpful to her. He then enrolled in one of her courses, one of her math classes or Algebra 1 classes there. He did well there in that class. And then he continued to be very respectful to this particular teacher, even so much so that the letter recognizes, Your Honor, that she called him to come back and speak to ninth graders when I think last year before the COVID-19 hit. She asked him to go speak to the ninth graders. So that speaks to the kind of person that he is in a school academic setting. He attends classes, he's passing all of his classes, and he is an enrolled active senior at Mount Zion High School. He has obviously missed 3 weeks of school up to this point. He's been in custody since the date of his arrest, Your Honor. And as we all know, that the studies have shown, Your Honor, that education is the #1 deterrent to recidivism, and that if he can actually get his education and do well, the statistics support that he is very unlikely to become part of the revolving door of our criminal justice system just by getting his education. Your Honor, to move a little further here, he has a $66,000 bond. If he's granted a reduction in his bond, he will be residing with his family members. He'll be residing at 317 Lossy Lane, McDonough, Georgia 30253. I've been told that is the address that he would live. He will continue to either attend Mount Zion High School.
Hold on a second. Spell the name of that lane.
Yes, I apologize. Lossie, Lossy Lane, McDonough, Georgia 30253.
All right, thank you.
Yes, Your Honor. So that is where he would, I'm being told that he would live. He has no prior felony criminal history. He has no prior FTAs. He's not out on bond on any other charges. He's not on probation for any conduct. And as we know, Your Honor, under the 8th Amendment, the purpose of bail is to secure the presence of the defendant. Its object is not to enrich the government or punish the defendant. The excessive bail clause of the 8th Amendment does not guarantee the right to bail, Your Honor. It does, however, guarantee that any bail that is imposed not be excessive in light of the perceived evil. Here, Your Honor, what we have is, just to give the court just a little factual background on the facts of the case. So Mr. Montrell Freeman is operating a vehicle that he had gotten just minutes or moments earlier from a friend of his. So he was going to get food for him and his friend, and the police get behind him, and the police officer's tag reader indicates that the car is stolen. Mr. Freeman is unaware at that moment that that car is stolen because he had gotten it from his friend. And as a result of that, the tag reader alerts that the car is stolen. The officer then blue lights Mr. Freeman, and Mr. Freeman doesn't stop the vehicle. And it turns into what amounts to a high-speed chase, Your Honor, just to be quite candid with the court. It's a high-speed chase that starts out on the streets, and then it gets on the expressway, and then it gets back onto the streets, and then it gets back onto the expressway, and ultimately, the officer, during this 10 to 15 minute chase, high pursuit chase, Your Honor, the officer then ends up doing a pit maneuver, a precision immobilization technique. He does a pit maneuver on Mr. Freeman's car on the expressway, and as a result of that, causes the vehicle to become demobilized. And as a result of that, Mr. Freeman gets out of the car. He runs on the median, crosses over the expressway, puts himself in harm's way, puts the officers in harm, other drivers and bystanders that are on the roads. This is the scenario that we end up with. They end up taking him into custody there on the expressway, and he's been in custody ever since. And Your Honor, in preparing for this hearing and other hearings that are similar to this, where there are high-speed chases that are involved, the vast majority of these high-speed chases, by the statistical data that I've been able to get, Your Honor, there's no national repository for keeping data on high-speed police chases. It's a voluntary basis where police agencies, they hand over information about their chases, deaths, injuries, and things of that nature, but there's no mandatory reporting. So we don't have complete, accurate 100% stats, but what we do have is what the National Highway Traffic Safety Administration has compiled over a number of years. And the vast majority, Your Honor, of these cases, these high-speed police chases, they involve offenders that have committed non-violent crimes that do not warrant exposing the public to these immense risks of chase. I guess what I'm suggesting to the court is that here we had a stolen car. There were no drugs in the car. Mr. Freeman was not wanted for murder. He was not wanted for rape, wasn't wanted for armed robbery or anything of that nature. It was a stolen car. And what the statistics say, Your Honor, is that these pursuits, they typically last between 1 and 5 minutes, with the vast majority of the crashes occurring within the first 2 minutes of the chase.
Judge, at this point, I'm going to object. I don't think this is relevant to whether or not the bond should be reduced for Mr. Freeman. And I know Attorney Matthews and I have spoken about this case, and I don't think this is the right forum where I think what the argument what he's making about whether or not, I guess, the chase should have happened, or all these statistics. I don't think any of those factors are relevant to whether or not the court should grant a reduction in this young man's bond.
Well, before Mr. Matthews, you respond to that, let me say that I have now received additional documents regarding the charges against Mr. Freeman. Initially, all I had was the first page of the warrantless arrest affidavit charging those offenses that I announced initially, but I have since I see that in addition to those 4 charges, he has 14 other charges, including hit and run, 2 other possession firearm charges, interference with government property, criminal damage to property in the 2nd degree. So I'll listen to your response to Ms. Freeman's objection.
Yes, Your Honor. So the state has indicated that it doesn't believe that this is relevant. I believe it's relevant, Your Honor, so that the court can understand the entire picture here to determine, well, we have an accused who is presumed innocent of these charges under the Constitution and under the law. However, the state is obviously going to get up, and when it gets an opportunity to present, they're going to talk about just how Mr. Freeman put the public at risk, how Mr. Freeman could have gotten himself killed, how Mr. Freeman could have, because of his actions, other people on the roads could have been killed, so forth and so on, and how the officers were put at risk, so forth and so on. That I would anticipate that would be part of the state's presentation. And I believe, Your Honor, in mitigation on behalf of Mr. Freeman, the court should at least have the opportunity to know statistically why certain police agencies have made a commitment to change its policies concerning high-speed police chases, and to what extent does law enforcement also contribute by continuing these police chases and putting the public at risk for police chases that involve crimes that are not violent. So I believe, Your Honor, only to the extent that it gets to counterbalance the argument that I anticipate is going to come from the state, so the court can at least hear that as on a policy level.
Why don't we do this? If in fact the state raises that as their objection to bond reduction, then I will allow you to come back and put that in.
Very
right
well.
Now I see someone who is fleeing from the police, which might be an indication they won't come back to court.
I understand, Your Honor.
All right.
So again, Your Honor, he has no prior history, Your Honor, of fleeing either in a car, or failing to appear in court, or failing to adhere to the administration of justice as it relates, that I'm aware of. If there is, I'm sure the state will get into it. I can tell the court that he is supported by his family, his mother, his aunts. He has no job. So if he is going to flee, he ain't going to flee very far. And I submit, Your Honor, that he's not going to flee. He has family members here in the state of Georgia, in Clayton County, Your Honor. Immediately after the incident occurred, Mr. Freeman was very contrite afterwards. He did not try to fight any of the police officers or anything of that nature. He didn't give a false name or anything of that sort. Your Honor, I would submit, Your Honor, that based upon those factors, he's not a flight risk. Since he's been in custody, Your Honor, I will tell the court that with COVID-19 been in place, Mr. Freeman has occupied a jail cell with 2 other inmates. Mr. Freeman has occupied that jail cell with 2 bunk beds, and he slept on the floor on a mat. He has been exposed to the potential for the virus, given the fact that he's in that room or has been in that room for a significant period of time with those other 2 inmates, and the conditions just haven't been that favorable for Mr. Freeman. I understand it's not the Ritz-Carlton, but we're just wanting to make sure, Your Honor, that even in the conditions that he finds himself, that they are suitable and habitable and safe for his protection. I would ask the court to consider that. I think more importantly, when the court set a $66,000 bond, the Ayala factors were considered, and the court determined that he met the Ayala factors in light of the fact that he did receive a bond. However, Your Honor, I'm asking the court to consider the notion and consider the possibility that under the 8th Amendment, when the Ayala factors have been met, when the determination has been found that he is a candidate for a bond, just as it has been exemplified by the $66,000, the question now turns to whether or not under the 8th Amendment that bail that's been imposed is excessive in light of what we have here. So I'm asking the court to take a stretch and consider that because he's been in custody for the length of period of time that he has been, because he's been unable to make the $66,000 bond, that it is in fact excessive. He has the nature of the charges are traffic related for the most part. And then we have the firearms, and we have a stolen car that he had the keys to. There was no indication that I'm aware of that Mr. Freeman would have known that the car was stolen before he got into it if his friend did not tell him. Mr. Freeman was forthright with respect to the weapon in the car. He indicated that he possessed one of the weapons. He was very candid with the court with the officers at the scene in that regard. There was never any attempt to use the weapons or anything of that nature, Judge. So I would respectfully ask the court to consider reducing the bond. The family has retained my services, so he is going to have counsel. He's missed 3 weeks of school already. He's not getting any educational credits right now because he's not in class. I would ask, Your Honor, that he be given a bond, that it be reduced. It's $66,000 plus now. I would ask the court under the circumstances to reduce it, cut it down to $30,000, which is basically half, a little less than half of where he is now. That there be restrictions, that he have a curfew, Your Honor. I'm not sure on any of these other bonds if there was a curfew that's imposed, that he have a curfew, that he be required to attend his classes, and that he have a curfew, that he continue to remain in school at Mount Zion High School, or whatever high school he's going to attend when he gets out, depending on where he resides, and that continue his education, have the curfew, and obviously we have no issues with him if the court requires that he not drive. We have no issues with that at all. If the court says you are not permitted to drive a vehicle while you're out on bond, we have no objections to that as well, Your Honor. We believe that those are reasonable restrictions and conditions on a bond reduction. We are asking the court respectfully to consider the arguments that I've made with respect to his background, his educational background, the facts and circumstances of this case, his lack of a prior significant criminal history, if any, his lack of being out on bond on any other charges, the fact that he has a bond, and more importantly, the fact that under the 8th Amendment, Your Honor, we're asking the court to take into consideration that perhaps because he hasn't been able to make bond for this significant period of time, that perhaps this is an excessive bond in light of the perceived evil. Thank you, Your Honor.
All right, Ms. Freeman.
Thank you, Your Honor. As I stated earlier, Mr. Matthews and I have talked about this case, and my argument is that the bond that is currently set on Mr. Freeman is reasonable. I had indicated to Mr. Matthews before that given the circumstances, given what happened, the fleeing from police, as soon as the police car got behind Mr. Freeman, he didn't stop, he didn't pull over, he kept going. You know, and then when the vehicle did come to a stop, he still ran. So, as well as having firearms. So given what the bond was set at his first appearance, Your Honor, and I have all of those amounts written down, the state believes that his current bond is reasonable. I did not see a reason for a reduction in his bond. And he does not have any priors. I didn't see any prior arrest or convictions on his GCIC, but given what happened in this particular case, when he had the opportunity to stop, he did not. He continued to flee, did not stop on his own, was essentially forced to stop. And that didn't work, and he continued to run. So at this point in time, the state believes that his current bond is reasonable.
And Judge, if I can just have a final word.
Yes, sir.
Thank you, and I'll be very brief. So, Your Honor, the state has argued in its recitation that fleeing has been the crux of why it believes, and that he did not stop the vehicle, and that he got out and he ran. I had an opportunity, we did an open records request, and we've been able to obtain the body worn camera and the dashboard camera from these incidences. And one of the things that came out of the mouth of Mr. Freeman when he was apprehended, he immediately indicated that he was scared. He said he was very scared. That came out of his mouth immediately. He said that to the officers. I was scared. I was scared. Then, of course, the officers were, you know, they didn't buy it, but that's what he said. Your Honor, he's 17 years old. At the $66,000 bond amounts to having to post $7,000 or $8,000. Unless you are a 17-year-older that has an incredible acting or entertainment career or just have rich parents, you don't have $7,000 or $8,000 laying around as a 17-year-old. And most adults who've been working every day in America don't have $7,000 or $8,000 just laying around in their savings account. That speaks very, very telling to me that when you put a $70,000 bond on a 17-year-old who has no prior history and has the background that I've suggested to the court, and we have conditions that are in place that we can put in place that can make sure that we can assure the court he won't be behind the wheel. We can assure the court that he's going to live in Clayton County. We can assure the court that he's going to be in school. That these become, and the fact that under the 8th Amendment, we believe is excessive, that these are in tantamount collectively, in totality, a reason to reduce the bond, Your Honor. I understand the state's position. However, Your Honor, I'm asking the court for some consideration here. Thank you.
Well, what concerns me, well, let me say that I understand the argument that's going to be raised or the defense that may be raised. I didn't know the vehicle was stolen. I had borrowed it from a friend to go get some food at 10 o'clock at night. I didn't know the guns were in the car. I was scared. When I saw the blue lights, I had no idea what was going to happen to me, so I fled. But we have, understand the facts were that at least one of the handguns was found on the defendant after he was eventually apprehended. We have seen in recent days how 17-year-olds act with a firearm. Kenosha, Wisconsin, 2 people are dead now because an irresponsible 17-year-old, and in this case, in Georgia, 17-year-olds are not supposed to be in possession of firearms. One of the reasons is because they don't have the mental maturity to know how to respect a firearm. Frankly, I think a $66,000 bail on all of these offenses where there's a fleeing and attempting to elude is reasonable. Give me just a moment. I had thought of something I was going to say and it slipped my mind.
Because I can say that typically in fleeing and attempting to elude cases, there are, if you look at the bond on this case, I think the fleeing and attempting to elude charge on it was maybe $5,000 or $10,000 on that particular bond. We're talking,
Mr. Matthews, that's an indication to me that there's a possibility he's not coming back to court. There's a possibility. Although the nature of these charges are not as serious as if he were charged with a murder or an armed robbery. I understand that. But here we have the public outcry that we don't need police chasing people because they get their tag number, they can find out who they are later. Well, not in this case, because the vehicle's stolen. That's not going to tell them who the driver of this vehicle was. They can't later go and apprehend him under more favorable circumstances.
what a lot of agencies are doing, Your Honor, what a lot of agencies are doing to combat that argument is police agencies some agencies across the country have equipped themselves with GPS bullets. And these GPS bullets, Your Honor, are technology that's been attached to police cars. They are on the front of these cars, and they allow them these bullets, they fire out if the police vehicle is within 20 feet of the car that they're pursuing, it will fire out from the police cruiser. It will attach to the car, and the technology is pretty advanced. It works 85% of the time, and that GPS bullet, they call off the chase, and that GPS bullet, Your Honor, allows that car to be tracked for up to 12 hours.
Yeah, and of course, now that everybody knows about that, the driver of that vehicle abandons the car. And because it was stolen, there's still no way that the police, law enforcement are going to be able to figure out who that driver was, except through perhaps fingerprints, et cetera. The other thing that I was going to say is that once people realize that if I flee, the police are not going to chase me. If I get caught, I'm going to get out on bail real quick. So there's very little deterrent there to prevent people from fleeing police officers. I recognize that he's young, has no prior record, and that's one of the reasons he has no prior record, I suppose, is because he's young. He's got a supportive family, and that's one of the reasons I think that bail shouldn't be any higher than it is. So the motion for bond reduction is denied. I'll prepare an order after the conclusion of this hearing, and one will be sent to all the parties.
Thank you, Your Honor.
All right, Mr. Freeman can go back with the deputy.
May I be excused, Your Honor?
Yes, sir. Thank you.
Thank you.
May I be excused, Your Honor?
Pardon?
May I be excused, Your Honor?
Yes, ma'am.
Thank you, Your Honor.
All right, I see that Mr. Hirsch is with us. Mr. Hirsch, your hearing was going to be the second one, which is now about to be called. If you will, turn your microphone on. Deputy, if you'll bring Reginald McCrimmon out. Court calls for hearing the case of State of Georgia versus Reginald Van McCrimmon for purposes of considering bail pursuant to OCGA 17-6-1. Mr. McCrimmon is present by Zoom video. He is charged with improper lane change, trafficking in cocaine, trafficking in methamphetamine, possession of marijuana 1 ounce or less than 1 ounce, and violation of Georgia Controlled Substance Act, possession of edible THC. The defendant is represented by attorney Max Hirsch. The state is represented by Assistant District Attorney Cheryl Freeman. This is Judge William West presiding by designation of the Superior Court. This proceeding is being taken down by court reporter Latasha Coleman and is being streamed live on YouTube. So, Mr. Hirsch, you may proceed. Mr. Hirsch, can you hear me? Mr. Hirsch.
I'm not sure if he hears us.
Mr. Hirsch, can you hear us?
I'm sorry. Yeah, I can hear you, sir.
All right, you may proceed.
Okay, thank you. Your Honor, in this matter, my client is a lifelong resident of Clayton County. He's 17 years of age. He has no prior criminal history. Ms. Freeman will obviously go into the facts of the matter. We had a preliminary hearing Monday, but he has no criminal history. He lives here in Clayton County. He had a little bit of a tumultuous youth or childhood. His parents gave him up for adoption. He was adopted by a local family in Clayton County. He grew up in Clayton County before that as well. But he lives with a Josephina Ortiz, and I have their address here in Clayton. He's gone through the 10th grade. He was working at a sandwich shop locally. His adopted brother also owns a restaurant where he has steady employment. It's a Mexican restaurant in Midtown on 10th and North Avenue. So I would ask you to give him a bond at this time. He, again, has no prior criminal history and is local to the area.
All right, Ms. Freeman.
Thank you, Your Honor. Attorney Hirsch is correct. This preliminary hearing was on Monday. And this is a case, Your Honor, where Mr. McCrimmon was stopped he was stopped on 75. He was the only one in the car. He was driving the vehicle. And THC edibles were found, as well as 26 vacuum sealed bricks. And this was suspected meth and crack cocaine. The approximate total weight, Your Honor, was 30,551 grams. Given the amount that was found, that is why I could not consent to a bond in this case. This young man, and as Attorney Hirsch said, he's 17, but he had a lot of narcotics in the car with him, and which would give us a street value of way over $1 million for this. And Attorney Hirsch, talked about this young man's youth, but at 17, he knows right from wrong. There was no one else in the car but him. And at this point in time, and I know he is on a no bond status right now. He does not have a bond on the trafficking cocaine, nor the trafficking meth. And it was just too much. The weight of what he had, like I said, over 30,000 grams. And I certainly think, given that there is certainly an incentive to not return it to court. But Attorney Hirsch is correct. There are no prior convictions for this young man. Again, he's 17. And so the state at this time is asking that he remain on a no bond status.
Mr. Hirsch, anything in conclusion?
No, well, yes, actually briefly. So I mean, the state's main argument here is because of the weight that the court shouldn't give him a bond, but he didn't have any identifying information in the bags which were in the back, and he's presumed innocent. So if this was like a murder case or a rape case, then I think the court should take into consideration certainly that the weight that someone could be violent and might be a danger to the community. The argument here, I guess, regarding Ayala is that maybe he will flee because the weight is so much, but he has no connections anywhere else in the world. All his connections are to Clayton County. He's not really a risk of flight. And if he is, we can put an ankle monitor on him. So because he's presumed innocent, I think the weight might go to whether he would flee or not, but his whole life is here. He's 17. He doesn't know anyone outside of Clayton County, essentially. So I just wanted to add that, sir.
Well, I think 30,551 grams of methamphetamine and 53.29 grams of marijuana is a danger to society. That much narcotics gets out on the street, somebody's liable to be harmed. But I also think that there's a substantial risk of flight. So as to the trafficking in cocaine and trafficking in methamphetamine, bail is going to be denied. So he can go back with the deputy, and Mr. Hirsch, you may be excused.
Your Honor, thank you. Have a nice weekend.
You too.
Thank you, Your Honor.
All right, Deputy, if you'll bring out Lauren McKinney Neal.
He's on the way out, Your Honor.
Thank you.
I need to hit the space bar at the top. I need to press the space bar at the top.
All right, the court calls for hearing the case of State of Georgia versus Lauren Michelle McKinney Neal for purposes of considering bond The defendant is charged with reckless conduct, aggravated assault for which no bond has been set, aggravated battery for which no bond has been set, and cruelty to children in the third degree. Both the reckless conduct and cruelty to children charges have bail set at $3,000. The defendant was before the magistrate court on July 12, 2020, and she is present by Zoom video, represented by attorney Randall Strozier. The state is represented by Assistant District Attorney Cheryl Freeman. This is Judge West presiding by designation of the Superior Court. This proceeding is being taken down by court reporter Latasha Coleman and is being streamed live by YouTube. So, Mr. Strozier, you may proceed.
Good morning, Your Honor. My client is Laura McKinney. She's 31 years of age. She has no significant criminal history whatsoever. The only criminal history she has is a very old marijuana case where she showed up in court every time that she was supposed to, and she completed probation first offender and had her record expunged by virtue of showing up when and where she was supposed to. She's 31 years of age, Your Honor. She's a stable person. She is gainfully employed when released. She had been laid off, but she's been recalled as a forklift driver for General Motors. She has 2 children, 2 females, aged 2 and 5. And she resides in St. Louis, Missouri. She was here in Clayton County visiting family. She has a lot of family that lives here in Clayton County, and she lived for a long time in this area, Judge. So she has extensive family ties to this area. Now, I want to point out to Your Honor that my client carries the presumption of innocence with her throughout these proceedings until said presumption can be is overcome beyond a reasonable doubt by the state. Now, if this case were to proceed to a jury trial, it would be my expectation that the jury would conclude that Ms. McKinney is not criminally culpable here. But we're not here to argue the facts of the case. Your Honor's aware that these are serious charges, but Your Honor's also aware that she enjoys the presumption of innocence throughout these proceedings. And what the court has to determine here is whether or not she poses a flight risk. Well, Your Honor, she has a job. She has a residence in St. Louis where she leases the house. She has children. She has family. Your Honor, this is a case that's going to require a lot of work, but my client needs to be out on bail to help her lawyer in her defense, and there's absolutely no reason to think that she's going to run. She didn't run before when she was in trouble over 10 years ago. She showed up where she was supposed to, and she has children. She has a job. She can't just go. She just can't go. Can't just go underground and go off the grid, Your Honor. That's not going to happen. And frankly, she has defenses here. She's already hired her lawyer. She hired a lawyer early on, and people that hire private attorneys to get to work on their case early on typically aren't going to run, Judge. So I don't see any risk of her intimidating anyone. Your Honor can place a no contact provision on bond to ensure she has no contact with the victim. But I'm certain that she will obey my instructions not to have any contact with him. And if Your Honor could also impose an ankle monitor if Your Honor felt the need to do so. But it is my absolute firm belief that Miss McKinney is a very good risk on bond, that she will show up in court where she's directed to do so, and that she will abide by any conditions that the court may place upon her for said bond.
All right, Ms. Freeman. Your microphone's off.
Your Honor, I'm looking at Ms. McKinney's GCIC. I don't have any information about something being expunged, but what I do show is this is in 2014, where she had a conviction for stealing, interference with arrest, and a possession with intent to distribute a controlled substance, where she was convicted. And I'm also showing in 2017 that she had a probation violation. So if there is something about something being expunged, I don't have that, but I do show she had a probation violation in 2017. Your Honor, this is a case where this defendant shot the victim in the head. And
Let me ask you, Ms.
yes, ma'am.
Freeman,
Yes,
do you know the age of the victim right offhand?
Yes, just give me 1 second. I can get
It
that.
looks like 32 years old,
Yes,
or will soon
I
be
think that's very,
32.
yes, yes.
Okay.
He was shot in the head, and he, when we spoke to his wife, she indicated that he was still in the hospital, and indicated that the victim cannot walk and actually had a seizure last week. And so, you know, this defendant shot the victim and left him there to die. And the victim's children were in the home, who were present during this shooting. So, Your Honor, and even as the attorney indicated, this defendant, her residence is essentially in Missouri. It's not here locally. So we certainly believe that given the charges, that there is a substantial risk that she will flee and not return to court. And that the fact that she shot this individual in the head, children were there, and she left him to die. She's a danger to the community. And so at this point in
Objection,
time,
objection, Judge. There's no evidence of that. She's going all into the facts of the case. That 911 was called, and when they arrived there, she was holding the alleged victim here, Judge. That's just false. I'm sorry.
Ms. Freeman.
Judge, I'm not going to argue the facts of this case with Mr. Strozier, but what I will say, she shot the person in the head.
You okay?
And the
Your
children,
Honor, I'm sorry. I'm sorry. Your Honor, I'm sorry. I'm sorry, Judge. She's allegedly shot him in the head. If this case goes to a jury, it is my belief the jury will determine that she's not culpable in this case, Judge. And that's my point. She enjoys the presumption of innocence at this point, Judge.
Judge, may I continue my argument? Because the information I'm stating is listed there in the probable cause affidavit, nothing more. But given the allegations in the case, again, the state believes that Ms. McKinney should remain on a no bond status, given that her residence is in Missouri, she does not have ties locally, and given the allegations that she is a danger to the community. So we are asking that she remain on a no bond status.
May I be heard again real briefly, Judge?
Yes, sir.
Judge, my client has a lot of extended family here. If she were ordered by the court, she could remain in Clayton County throughout the duration of this case. That would not be an issue. My client has never been accused of a violent crime before, so I think it's a stretch to say that she is a danger to the community. I believe that she's a very good candidate for bond, and she's willing to abide by any conditions or restrictions the court may impose, Judge. including an ankle monitor, including remaining here in Georgia. Her mother and children are willing to relocate back here to be with her. They're all from here originally. So if Your Honor were to order her to remain here, that's really not a problem.
I find that there is insignificant ties with the community, that there is a likelihood the defendant will not return to court. I'm going to deny bail on the aggravated assault charge and aggravated battery at this time. She was arrested, taken into custody on July 11th. So she's only been in custody about 6 weeks without bail on those two charges. So she can go back with the deputy. I'll prepare an order after this hearing, after the calendar, and send copies to you, Mr. Strozier, once it has been filed. So you can be excused.
Thank you, Your Honor.
Thank you, Judge.
All right, Mr. Studdard, we're ready for your hearing. And Deputy, if you'll bring DeLacy Young Wilson out.
Yes, Your Honor.
Can you now see me on your camera, Judge?
Yes, sir.
Okay. I just, it's all new to me, Judge.
Court calls for hearing the case of State of Georgia versus DeLacy Robert Young Wilson for purposes of considering bond pursuant to OCGA 17-6-1. Mr. Young is charged with felony murder and also aggravated assault, for which bond was denied. Mr. Young is before the court by Zoom video, represented by Attorney James Studdard. State is represented by Assistant District Attorney Cheryl Freeman. This is Judge West presiding by designation of the Superior Court. This proceeding is being taken down by court reporter Latasha Coleman and is being streamed live by Zoom video, by YouTube. So, Mr. Studdard, you may proceed.
Thank you, Judge. Judge, we're not going to belabor the court with the tenets of the requisite contained in 1761 of the code. The Honor is very well familiar with those. Probably hears them every day, so I will also by those suggest that my client that does meet the requisites of at least that code section. Moreover, Judge, there was a preliminary hearing in this matter on the 17th day of this month.
Hold on just a second, Mr. Studdard. Ms. Coleman, can you understand Mr. Studdard?
I was just about to interrupt, Judge. He's a little low. I would, yeah.
Maybe, Mr. Studdard, you need to get a little bit closer to your microphone.
How about this?
Is that any better? Try it again.
Hello, I'm speaking right into the mic now.
Perfect.
Okay.
Thank you.
Thank you. I'm sorry for that, Judge. At any rate, Judge, there was a preliminary hearing that was held on the 17th day of August, attended by the lead detective, a lady by the name of Jennifer Langley. And I might just comment, Judge, at this point, based on her testimony at that hearing, there was a video of this entire matter taken down on the property camera that will no doubt be used in evidence at some point in time. This case arises out of, Judge, basically it's a triangle. My client was at the time of his arrest was living at 6967 Beaver Trail, Riverdale, Georgia, with his roommate, a fellow named Dennis Dozier. My client was gainfully employed at a place called Kebab Gourmet Foods, Judge, and what they do is manufacture. They don't sell to the public, but they were shut down because someone at CDC had the notion that they should be shut down because of COVID-19. So he was out of work since this so-called pandemic began. But he was a resident and is a resident of Clayton County, Georgia, as well as his mother, who lives in College Park, Clayton County, Georgia. And Judge, my client freely admits that a shooting took place. Freely admits he had the weapon. He's unapologetic for what he did. He's sorry for the man who was killed in this situation. But given the facts, Judge, as it develops, this fella came over to my client's house on at least 3 occasions looking for his estranged paramour or girlfriend or whatever name we want to apply to her. And he came on the 22nd of June and beat on the windows, beat on the doors. My client told him to stay away from my property. He came on the 23rd again next day, and he got into an altercation that day with my client, and my client's roommate had to stand between the two to break up an altercation between the two at that time. I believe also he came back on the 25th, but on the day of the shooting, when he came over, Judge, he came over, and the girl was already at my client's property, the one he was chasing. He came over. They had some colloquy. My guy came out of his house with his gun. He said, "Get off my property." Told this man, "Leave. You need not come back here anymore." My client then gets in his car, and as he's leaving, he says, "You're dead. You're dead. You're dead" to my client. And then after he leaves, he comes back. And when he comes back, he gets out of his car, and then of course they're on my client's property again, and another argument ensues, and the deceased goes towards his girlfriend's car, and my client believes that the girlfriend, and he's seen this gun before, had a 9mm in her car. So my client doesn't know what to expect at this time. He's heard the guy threaten to kill him. He's been over 3 times disrupting this man's life. My fellow shoots up in the air one time, does not deter the gentleman. He then starts to fire this weapon, shoots it many times, Judge. Again, admits freely, shot it many times in self-defense, hit the car many times. Testimony was that there were several holes in the car, and one or more of these bullets struck the deceased. The deceased got in his vehicle, backed out, drove across the street, and wrecked the vehicle into a neighbor's car across the street. And that, Judge, is pretty much the sum of what happened. There's, of course, there's more meat to be put on the bones, which I'm sure Ms. Freeman will somehow come up with some at the trial. But Judge, my client, of course, contended that I know it's a novel idea nowadays to stand your ground because you take a chance of being charged yourself. But he felt like he was standing his ground. He was threatened. His life was threatened. There was a criminal trespass going on at the time. And for at least those 3 reasons, Judge, there's sufficient evidence to at least grant this man a bond. He's been in jail since July the 2nd of this year for protecting his own house, his own property, after having to tell this man, "Stay away from my property." Granted, 10 or 11 shots is rather overacting, Judge, but in a situation where with that kind of heated rhetoric and the excitement of all that, what was going on, my client, again, is not apologizing for what he did. They want to shift the blame to anybody, not the police, not anybody, but himself. He shot this man. Didn't mean to. He was trying to just get him off his property. And one of these errant bullets, there's some negligence involved, Judge, but not murder. It's self-defense, stand your ground, criminal trespass. Where do we draw the line, Judge? And I'm suggesting that in this facts, the law, the good conscience dictates if we're going to allow this sort of thing to happen and have the defendant stay in jail for defending his rights, and we've come to a sad place in our society, I would ask this court to please grant this man a bond. He lives in Riverdale, Georgia. His mother lives in Clayton County. He has, hopefully, when the CDC or the World Health Organization makes up their mind about COVID, he can go back to work at Kebab Gourmet Foods. I would respectfully ask this court to grant him a bond so that he can go get back into society and try to get back to work and live a normal life. Thank you, Judge.
Ms. Freeman?
Thank you, Your Honor. Most of what Attorney Studdard indicated was testified to, but for, I think it is his client's contention that he thought that the victim was going to get a gun out of the young lady's car. That was not something that came out. I will say that this defendant, he does have a little bit of a history, and I'll start with that first. It begins from what I have from 2005. There's a fleeing and suspended license, which is essentially most of what the defendant has. In 2010, there was a DUI. In 2012, there was a suspended license. In 2011, there was another DUI and a suspended license. In 2016, there was another suspended license, as well as an obstruction. There was a probation violation in 2016. And then we have the current case. Your Honor, I will say that, of course, the decedent's family is opposed to a bond. In fact, the family member that we've been speaking to indicated that that I believe that they have been knowing this defendant for years, and they are really distraught about what happened. But given that he does have a fleeing in his history, he has the probation violations in his history. We do believe that, especially given that he has been charged with murder, that there is a likelihood that he will reoffend or not return to court, given his probation violations as well as the fleeing, even though the fleeing was in 2005. So, Judge, we are asking that on the murder and aggravated assault that Mr. Young Wilson not be granted a bond at this time.
I'm a little bit confused. I think the name of the victim that Mr. Studdard mentioned is different than what I see in the arrest warrant. The arrest warrant identifies the victim as Tiamo Thorpe, and I don't recall.
That's the name, Judge. Yes, Thorpe.
That is his name.
Okay, I'm sorry. I thought Mr. Studdard said some other name. Okay. Anything in conclusion, Mr. Studdard?
Yeah, Judge, very briefly, the salient point that Ms. Freeman made, and the telling point, I think, is that he has never been, he never ran out on a bond, never skipped bond, and all these charges that he's faced with or has had, were moving violations involving a little bit too much of the devil's elixir and drinking while imbibing. And as to the gun being, that is one of the hazy parts about this case, Judge, is where was the gun, if there was a gun. However, there is no doubt that the victim said 3 times, and he'd been over there to this man's house on 3 different occasions, beating on his doors and windows, and said, you're dead, leaves and comes back. What then shall we do? What then shall we do if it's us? What do we do then? And I'm saying that's the gravamen of this case. That's the crux of this case. Where do we draw the line when people come to your property? How do you hold this client to a standard of care above what the police are held to? And police have a tough enough time now to reacting to a split-second situation like this, and here this as a layperson with a man who's threatened him on 3 occasions, comes back, threatens, actually makes a statement that's paramount to a threat to kill him. And I think my client acted completely within his rights, and I would ask the court to allow this man to have a bond. And he's never been on bond again for any felony, anytime, anywhere. So I think he does satisfy the tenets set forth in 1761, Judge. Thank you.
Mr. Studdard, you previously indicated that there is a video of the incident. Is there also an audio recording?
I understand that there is, and there's also there's 2 other videos that we're trying to get a hold of, that when he came on prior occasions over there, on at least 2 times prior, and my guy wouldn't let him in his house. And Detective Langley, she's trying to get that now for the police department. She's in the process of securing that. But we do have the video of the actual shooting, and I believe it's audio and video.
Ms. Freeman, did Detective Langley testify about the whether or not there was evidence the victim made threats to the defendant?
If I recall correctly, I think she indicated that the victim had come over to the defendant's house previously. I don't believe that there was any testimony that that the police or anything like that had ever been called, but I do recall Detective Langley indicated that I think that was a statement that had been given to her.
Judge, just one quick aside, and I don't mean to take a double argument here, but the reason I think a lot of the reason the family is so distraught about this is that my client and the deceased were high school buddies together, grew up together, knew each other well, and I think that's disturbing for the parents of the deceased. And I understand that, and it disturbs my client too to have to get involved himself in this. Thank you.
All right, under the circumstances, I am going to set bail on the felony murder charge at $100,000, on the aggravated assault charge at $50,000, with the condition that the defendant is to have no contact with the victim's family, that he is to wear an ankle monitor and have it attached before he is released from jail. He is not to violate any laws while on bond. He is not to leave the state of Georgia while he is on bond. I'll prepare an order after the conclusion of this morning's hearings, and a copy will be sent to you, Mr. Studdard. So Mr. Young can go back with the deputy, and Mr. Studdard, you may be excused.
Thank you, Judge, and thank you, Ms. Freeman.
Thank you, Ryan. See you, Mr. Studdard.
Oh, okay.
All right, now I think that gets us to the public defender's cases. I'm allowing someone by the name of Moni Bland. Ms. Freeman,
Yes, Judge. Yes, Miss Bland, Monica Bland, she's one of our supervisors in our victim services unit. Miss Wyatt will have to get off the call pretty soon for a meeting, and Miss Bland will be taking her place.
Okay. All right, so the first case that we have for hearing with the public defender's office is State versus Zakiyah Carter. So Deputy, if you'll bring Zakiyah Carter out.
Yes, sir.
Court calls for hearing the case of State of Georgia versus Zakiyah Martin Carter for purposes of considering bond pursuant to the defendant's motion for bond. The defendant is present by Zoom video, represented by Attorney Nelson Rhodes. Mr. Carter is charged with several offenses for which bond was denied at first appearance on May 30th, particularly aggravated assault, fleeing from police officer, possession of firearm by convicted felon, violation of Georgia Controlled Substance Act, possession of a weapon during the commission of a crime, and another count of aggravated assault. The state is represented by Assistant District Attorney Montrell Freeman. This is Judge West presiding by designation of the Superior Court. This proceeding is being taken down by court reporter Latasha Coleman and is being streamed live by YouTube. So, Mr. Rhodes, you may proceed.
Thank you, Your Honor. Good morning. Mr. Carter was arrested and has been in jail since May 29th, 2020. His case has not been accused or indicted, and he currently has no bond set. So we're here before the court pursuant to Georgia Code 17750, where under the circumstances, he's required to have a bond set after the 90 days have passed without bond. The 90-day period was reached on August 27th, 2020. It's currently August 29th, or 28th actually. So 90 days occurred yesterday. Mr. Carter has a job with Marcus Landscaping that will still be waiting for him upon release. He is a detailer and landscaper. He's from Atlanta. He's lived in Atlanta all of his 40 years. Further, all of his family, except one of his 13 children, lives here in Georgia as well. One daughter currently has gotten COVID-19 and is seeking treatment. And as Your Honor knows, the virus has ravished communities and he needs to get out to see and attend to his daughter. Meanwhile, he also helps his elderly mother a lot as well. His mother needs hip replacement surgery, and he just helps her around the house with cleaning, getting items until she can get her surgery. With all of that, he is a family man, not a threat to the community. He's a provider. He attends Mount Carmel Baptist Church in Atlanta. He currently lives with his girlfriend, Miss Lula Stanley. He's not going to be a flight risk. And Your Honor, we don't believe that he would be of any intimidation to a witness. The alleged victims here are Clayton County police officers. The likelihood to intimidate a police officer, I hope we can understand, is extremely low. It's not really a fight that you can win. But anyway, the likelihood to, I'm sorry, Your Honor. I'm sorry, Your Honor. When I get certain calls through my computer, it comes through. I just need a moment. All right, to resume. So yeah, he is a family man. He has significant ties to the community. He's unlikely to intimidate any witnesses upon release. And he is required by law at this point to have a bond set for his case, which is unindicted at this point. And of course, we don't even know when grand juries are going to reconvene. So if we can ask the court for a reasonable bond to be set for his charges, Mr. Carter can only realistically afford a $50,000 bond, and that's what we're asking. We believe that that's reasonable. With 50,000, it is pretty much all of his money, or all of the money that he believes that he can even put up. And, you know, bonds, as we know, are not supposed to be punitive, but just enough to assure reappearance at court. $50,000 in this case, we do believe is reasonable in the aggregate for his charges, but we just submit that number for your consideration. Thank you.
Ms. Freeman?
Thank you, Your Honor. This is a case that started from the sheriff's office had a road safety check, and Mr. Carter was the driver of a vehicle, and a chase ensued after this. The deputy was speaking to, was asking Mr. Carter for his license, and then when asked Mr. Carter to place the vehicle in park, he asked him to step out of the vehicle, and then at that point, Mr. Carter placed the vehicle in drive, and a chase ensued. And the narcotics were located when the vehicle stopped. And the two victims are deputies, Your Honor, that during this encounter, Mr. Carter almost collided into two different deputies. So those are the victims of the assault. But just, you know, and I know Mr. Rose made an argument saying that bond is, the purpose is to ensure that he'll return. Well, given Mr. Carter's history, and I will certainly go through that the state certainly believes that there is a substantial likelihood that Mr. Carter will not return. And so I'm going to begin from his history starts from, and this is without any probation violations. It starts from 1999 with a robbery. 2000, we have a suspended license. 2003, an aggravated assault. Another aggravated assault in 2003. 2006, possession of a firearm by a convicted felon. 2013, given a false name. 2013, another aggravated assault and a burglary. In 2019, possession of a weapon during the commission of a crime, possession of a firearm by a convicted felon, and a robbery. And he got 7 years probation in Fulton. And so that's still current. 2018, a criminal trespass. And in 2018, also riot in a penal institution. And again, Your Honor, I didn't even go through the probation violations that Mr. Carter has in his history, but just given the charge that he has, that certainly that any bond the court decides on, I think would certainly have to be much higher than what Mr. Rhodes was asking for to ensure that Mr. Carter will show up for court, given his history. Clearly, he has shown that he has a disregard for the laws of the state of Georgia. And so given his history and the convictions, you know, and I understand that he has been in since in May, I believe, and that he is entitled to a bond. So if the court is inclined to grant a bond in this particular case, Your Honor, and he does have a lot of different charges in this particular case, and the state is asking for at a minimum of $150,000 with a GPS and not leave the state of Georgia. And that's all I have, Your Honor.
Mr. Rhodes, anything in conclusion?
I'm sorry, Your Honor. I'm getting another phone call. I don't want to be interrupted. You all can hear the rings as well, right? Yeah, I'm sorry.
We all have to deal with these circumstances under these trying times.
Yeah, I'm sorry. I really need to figure out how to mute that or turn that off whenever I get like a Google call coming from my computer. Anyway, the only thing that we would add, of course, is that we would be amenable to, of course, a GPS angle monitor or a curfew, you know, whatever it might take to ensure that he will be tracked, he will be traced, he's not likely to flee, he'll be accounted for. You know, the state's concern about his, you know, likelihood to flee or whatever, I believe that that can be addressed just simply with an ankle monitor. He will be accounted for. He can be tracked down. He can be found. So respectfully, we submit that to the court as well for consideration. And again, we ask for 50,000 in the aggregate. Thank you.
All right, I'm going to set bail as follows. Now, the bail that was set at first appearance is going to remain. And as to the charge of aggravated assault, each of those will be set at $50,000. As to the charge of fleeing from police officer is set at $5,000. Charge of possession of firearm by convicted felon is $10,000. The charge of violation of Georgia Controlled Substance Act is $10,000. Charge of possession of a weapon during the commission of certain felony is $5,000. I believe that totals $138,000. There'll be a condition that he is to have an ankle monitor and that he is not to leave the state without permission of the court. I'll prepare an order after the conclusion of the hearings this morning and send copies to both of you. Mr. Carter can go back with the deputy. You have one other hearing, don't you, Mr. Rhodes?
No, that's all for me. It will be Camille Reddick, I believe, from now on.
All right, then you may be excused if you'd like.
Thank you. I'll remain, but thank you.
Okay, go over page 4. So, Ms. Bonnie,
I think the last hearing we have is from Ms. Reddick, Willie Reeves.
Yes, Your Honor.
Court calls for hearing the case of State of Georgia versus Willie Ernest Reeves for purposes of considering bail pursuant to OCGA 17-6-1. The defendant is present by Zoom video, represented by attorney Camille Reddick. The state is represented by Assistant District Attorney Cheryl Freeman. This is Judge West, presiding by designation of the Superior Court. The proceeding is being taken down by court reporter Latasha Coleman. And the proceeding is being streamed live by YouTube. The defendant is charged with armed robbery and felony murder, for which bail was denied pursuant to OCGA 17-6-1, and 2 separate counts of aggravated assault with deadly weapon and possession of firearm during the commission of certain felonies, for which bail was denied by the magistrate court at first appearance on July 4th, 2020. So, Ms. Reddick, you may proceed.
Good morning again, Your Honor. Mr. Reeves is a 26-year-old. He is a lifetime resident of Georgia. He has no prior criminal history. Looking specifically at the Ayala factors, Your Honor, he is not a threat or risk of flight, as he is a lifelong Georgia resident. He, in fact, has been living in College Park for a significant amount of his life, but he also has lived in other metropolitan Atlanta area cities and counties. He is not a threat to harass or otherwise intimidate witnesses. It is our belief that once all the facts of this case are fleshed out based on cell phone data, it will be shown that Mr. Reeves was not anywhere near this location at the time this incident occurred. He does not know the victim. He does not know the victim's family, so he will not have contact with folks he does not know. With regard to his likelihood to reoffend, he has no history. He's made it 26 years within the state without ever being arrested for or being convicted of any crimes within the state. The point of a bond, as everybody said, and I know I'm sounding like a broken record, Judge, is to secure attendance at future court dates. I believe, based on this young man's lack of history, prior criminal history, his significant ties to the community, he does not know the victim's family, we think he would be a good candidate for bond. And for Your Honor's note of edification, this young man has only been in custody for 57 days.
All right, Ms. Freeman.
Thank you, Your Honor. Your Honor, this, from our understanding, and I know it was listed on the warrant, is that this was a situation where there was supposed to be, or allegedly, a transaction involving purchasing marijuana. And during this transaction, the defendant shot 2 people. One person was killed. And then the other person was shot, I believe, in the arm and maybe the abdomen. The defendant was positively identified from a lineup by the individual who was shot in the arm. The detective on the case received, took a screenshot of some text messages where allegedly this defendant confessed to the shooting. And
Your Honor, at this point, I'm going to object. I believe we should be focusing more on the Ayala factors as to why this young man might not be a good candidate for bond. The state is providing information that the defense is not privy to, and thus we're not able to provide any reasonable defense.
You raised the defense of when the cell phone records are provided, it's going to show he wasn't there. Now, to me, that doesn't prove he wasn't there. It might prove his cell phone wasn't there, but that cell phone could have been anywhere, and he could have been somewhere other than the cell phone. So I think that the state has a right to bring up the facts that they alleged occurred in response to that. So Ms. Freeman, you may proceed.
Thank you, Your Honor. And Your Honor, the information that I'm providing is not coming from a detective's report or anything. It's the information actually that was provided when getting the warrant. And I wanted to point that out regarding the Ayala factors, that certainly I believe that that there may be a potential to intimidate witnesses. You heard me indicate that there was a victim who was shot, who gave a positive ID regarding the defendant. So we certainly think that there is a potential for intimidating a witness, as well as the people that Mr. Reeves may have sent a text message to regarding the shooting. Given the charge itself, we also believe that Mr. Reeves poses a danger to the community, as well as there is a potential that he certainly may not return to court, given that he has been charged with these serious offenses. So with all that said, the state is asking that the court deny the defendant's request to grant a bond.
Anything in conclusion, Ms. Reddick?
Yes, Your Honor, I do believe the Supreme Court of Georgia has said that merely someone being charged with murder is not a sufficient basis to deny their bond. So the state arguing that the fact that he's charged with murder means he might not show up fails. Additionally, I believe the fact that he may have sent text messages to somebody that is not quite correct, Your Honor. So again, I would just focus mainly on the Ayala factors, his significant ties to the community, his risk of flight. I haven't heard anything from the state beyond the fact that he's charged with murder means he can run, which the Georgia Supreme Court has already decided is not sufficient. His likelihood to reoffend, haven't heard anything from the state on his likelihood to reoffend in light of the fact that this young man has no other history. This is the first thing he's ever been arrested and charged for. And his chance of risk of intimidating or harassing witnesses, again, our position is he doesn't know these people. He didn't know them at the time. He doesn't know them now. That's not something he's going to do because he doesn't know them. We have not heard anything from the state saying that they've gotten messages from him or people that know him saying that we're going to do X, Y, and Z to you. So I believe at this point, the state has not carried their burden to say that he should not be entitled to a bond based on the Ayala factors.
I find that there is a substantial likelihood or risk to potential for the defendant to intimidate witnesses in this case, and that there is insignificant ties to the community such that there would be a substantial risk of flight. I'm going to deny bail on all of the offenses so he can go back with the deputy, and I'll prepare an order and send it to both of you in just a few moments. I think that concludes all of the business on the calendar this morning. So Ms. Reddick, you can be excused. Ms. Freeman may be excused, and all other attendees may be excused.
Thank you, Your Honor.
Judge.
Thank you.